you?
Hi, Robin. I'm well. How are you?
I'm good. I'm good. Staying healthy, right? I mean, social distancing
Yes,
is going
well,
well,
we're all doing our best.
right? So, I mean, I really appreciate you coming on today to talk a little bit about, um, finances. Bankruptcy is one of these topics that's coming up slowly but surely when people realize, having an economy closed down, it really has an impact on your bottom line. And one of the things I wanted to do was just to have a little bit of a conversation, not to go too far into the weeds, but like introduce the idea of bankruptcy because that's your specialty. Why don't you tell us about your business first and then and what you do, and then we'll establish you as that great expert and we'll get some
Okay,
questions answered. How about
there,
that?
there you go.
Okay.
Thank you, Robin, for this opportunity. My name is Ethan Gantz, and I'm the principal of the law office of Ethan Gantz. We're a full-service law firm consisting of 3 lawyers, but one of our primary practice areas is bankruptcy / insolvency / creditors' rights, which is what we're going to be discussing today.
Good, good. Okay, so what is bankruptcy?
Well, what is bankruptcy? It's a great question, and I like to point out, by the way, that bankruptcy was contemplated by the founders of our country, and is actually enshrined in the Constitution in Article 1, where Congress is empowered to promulgate uniform bankruptcy laws. So what bankruptcy is a set of laws that provide a uniform, orderly, and equitable way of addressing debt.
That's concise. And I'm knowing a lot of people that are really need to understand their debt and what options they have, and maybe knowing when is it a good time or why anyone would file bankruptcy, and then maybe why wouldn't a person do it?
Right, and let me just start out by saying that there is, in many quarters, a misconception that bankruptcy means that a business is shutting down, i.e. ceasing to operate, but that's not the case. So I think it's a good segue for telling everybody basically what the options are that are out there in terms of different proceedings under the bankruptcy code. And I'll just get a little wonky for a second and just say that it is, as I say, federal law. It's Title 11 of the United States Code that has all of the different bankruptcy provisions. All of these different chapters that you've heard about that I'm going to talk about in a moment are chapters of Title 11 of the Bankruptcy Code. So, what are they? And again, I'm only going to talk about the ones that are relevant to individuals and businesses. There is bankruptcy for municipalities that I'm obviously not going to talk about. That's not going to be applicable. And family farmers, I don't think we're going to have too many of those. So I'm going to focus on the ones that are relevant to most of the people that you and I are dealing with. And so they're as follows. There's Chapter 7, Chapter 11, and Chapter 13, and I'll explain what each of those is. Chapter 7 is available to both individuals and corporations, including nonprofit corporations, which are also corporations. And Chapter 7 is the simplest type of proceeding. It's also known as a liquidation because to the extent there are any assets that are not exempt in the cases of individuals, a subject I can talk about a little bit later. The assets are, well, I should say there is a trustee appointed. That's a third party whose job it is to determine whether there are any assets, and if so, to liquidate them for the benefit of creditors, and then they are then distributed in accordance with the priorities set forth in the bankruptcy code. So that goes to the issue of the orderly and equitable distribution of assets. Bankruptcy code sets forth a list of an order in which creditors receive distributions. And that's true for all types of bankruptcy. But again, in the Chapter 7, it's a relatively simple process. There are assets, the trustee liquidates them, administers them, and that's it. The debtor, which is the word we use for the entity that files for bankruptcy, doesn't have to make any kind of additional payments. Now, to be clear, in the case of a business, this is the option where the business would be shut down.
Mm-hmm.
However, there is also available to both individuals and corporations, although you hear it much more in the context of corporations, Chapter 11, which is a
Reorganization.
heard, which is right, which is a reorganization proceeding. Now again, I'm going to focus on it is available for individuals who have very large debts, high net worth individuals. I mean, people, just to give you an example, Mike Tyson filed a Chapter 11. So these are people who are extremely wealthy and have very complex financial lives.
Mm-hmm.
For most individuals, it's not going to be applicable. It's going to be for businesses.
Mm-hmm.
Now, again, in a Chapter 11, the business is generally not shutting down. What it does is it gives the business an opportunity to, in some cases, to restructure some of its debts and continue to operate as a going concern, if that's what it wants to do.
But there would be a trustee in this case too.
No,
no trustee.
No, that's the novelty of Chapter 11 is that, and this is not, at this point, not unique to the United States, but a concept that I think was at least pioneered here. The debtor continues to operate as what's called a debtor in possession, and so there is in fact no trustee. The debtor's existing management continues to operate, but just the entire process would then be under the oversight of the bankruptcy court.
Got it.
And again, there within Chapter 11, there's a lot of flexibility given to debtors to reorganize some of their affairs. So for example, one of the major things that is beneficial for businesses in Chapter 11 particularly is the ability to assume or reject leases. So if a business has, let's just say, a very burdensome long-term lease, there is the ability to, and this is the bankruptcy term, to reject the lease and so the company sheds itself of this lease, and then the landlord has certain claims in the bankruptcy, but the lease can be effectively terminated if it's say too burdensome, and so it allows a company to continue to operate. Say, for example, it has multiple locations and wants to narrow it down to fewer than it had.
Mm-hmm.
It could say, but let's just say it wants to keep one location. It can keep that one location. It could assume that lease if it wanted to, and it could reject the other location's leases. And again, the consequences of the rejection of that lease would be dealt with through the bankruptcy process. One thing that I want to say, I should have said generally, is that one of the great benefits of a bankruptcy proceeding is, again, going back to the whole concept of orderly distribution. Mm-hmm. What bankruptcy does is it prevents what they call the quote-unquote race to the courthouse, i.e. having creditors suing left and right, and the most aggressive creditor getting all of the assets or getting all of the benefits. In this case, in any chapter, whether it's 7, 11, 13, or one of the other ones that I'm not going to talk about, the moment that a debtor files for bankruptcy, an automatic stay goes into effect, which prohibits creditors from taking any actions to collect upon a debt that arose prior to the bankruptcy filing. So it's not just, it stops lawsuits. I mean, you can't even call and say, hey, pay me money. It's a pretty much blanket, absolute
timeout. It's a timeout, right? Exactly.
Timeout. That's exactly right. A timeout to allow the debtor some time to think about, what do I want to do with this obligation? What do I want to do with that obligation? And, again, in the case of Chapter 11, decide how to deal with it. Again, in a liquidation scenario, it's going to be a different story.
So there's a new provision then. I'm I'm seeing in my notes that there's effective February this year. There's some
Well,
changes.
so yes, so there's some good news for small businesses. There's new legislation that's effective, as you say, in February of this year, so brand new, called Subchapter 5 of Chapter 11, and that contains provisions for small businesses. And what it does is it creates a more streamlined process for small businesses. And there's even better news for the next year or so, which is that the CARES Act, this $2 billion stimulus package that contains a whole variety of provisions, increased the eligibility under what's termed a small business for a maximum of $7.5 million in debt. So in other words, a small business can have up to $7.5 million in debt. When it went into effect a month ago, it was 2.7 million. It will go back there in a year, but for the next year, that debt threshold goes up, what, two and a half times what it was before.
Right. Wow. Yeah, and that's to take into consideration everything that's happening and to streamline it. I imagine it's a very difficult process as well. So this makes it a little easier, takes some of the burden away.
Yes, Chapter 11 is a very complex process.
Yeah.
And this makes it, I don't want to say it makes it easy, but it makes it easier, and it eliminates some of the requirements of a regular Chapter 11 that would be particularly difficult for a small debtor to have to deal with, and difficult also, by the way. Anything that's complex makes it more expensive in terms of legal fees. So this would cut down on those.
Okay, so then you have Chapter 13 as well.
Right.
Okay. What is that about?
The last chapter I want to discuss is indeed Chapter 13, which is basically a wage earners repayment plan. So this is applicable only to individuals. There are and I'm oversimplifying for purposes of this conversation, but essentially what happens is you look at the debtor's income and you look at the debtor's expenses, and the difference between those two, that amount of money has to be put into a plan of reorganization that has to be approved by bankruptcy court. That amount of money goes into a plan for a period of either 3 or 5 years, depending on certain factors that I'm not going to get into now. After which, so a portion of debts, or in some cases all, depending on how much the debts are, get repaid, and then the debtor is entitled to a discharge of his or her debts.
Okay.
So it's similar. It's a much more streamlined version of a Chapter 11 for individuals.
Okay. That makes sense. I mean, these are very difficult decisions because they'll impact you for years to come. I mean, what's the negative impact to obviously your credit and, future business opportunity? Those are the things to take into consideration as well.
Right. So the impact to your credit is as follows. The Fair Credit Reporting Act provides that a Chapter 13, and again, of course, we're talking about individuals here. Chapter 13 will remain on your credit report for 7 years, and a Chapter 7 will remain on your credit report for 10 years. So it's going to be there. But I always like to stress to clients and potential clients is that if they are delinquent on payments, those are also negative credit events that are going to show up. And by the way, and if there are lawsuits against them or judgments against them, those are all going to show up on a credit report. And in some circumstances, the issuers of credit make whatever determinations they make based on whatever proprietary analyses they make on whether or not to extend credit. But in some ways, if an individual has filed for bankruptcy and has gotten rid of debt, they may actually be better credit risk to a potential lender because they have dealt with those other debts that were previously delinquent and outstanding.
Okay. I understand. So a lot of people get into personal debt because of their business. And that probably
Yes.
applies to many of the smaller businesses and the kinds of businesses that we meet out in our groups and in our networking groups. What are you thinking
That,
about that?
yeah. So that's thank you. That's a very good question, and that's exactly right. A lot of times, a very common scenario for me is that somebody will come to me and tell me, my business is kaput. I mean, it's either it's not functioning, it's closed, or it's barely functioning. It has no assets. It 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 can't be rehabilitated. But I, the principal of the business, have been required, as is generally the case with most small businesses, to personally guarantee certain obligations of the business. Most commonly, you'll see lines of credit require personal guarantee,
Mm-hmm.
and leases will require personal guarantee, even though there are sometimes limitations on that. But there's still typically a personal guarantee on a commercial lease. And for a long-term commercial lease that is delinquent, that can mean a lot of money. Because what happens, of course, in all these instances is that somebody stops paying for even a month. Typically, what happens is that the lender can do what's called accelerating the lease, which means the entire amount that would be due over the life of the lease or the loan becomes due immediately. And again, in a long-term lease, that could be
A
hundreds of
disaster,
thousands or millions
right?
of dollars, depending on what the rent is. So anyway, somebody gets stuck personally with those liabilities, he or she often may be able to benefit from, even though the business may not need to file for bankruptcy. There are often, I will interject one thing, which is to say that there are often reasons that a business that is not operating and doesn't really have much in the way of assets or anything in the way of assets doesn't benefit from a Chapter 7, but the individual may well benefit from that.
Okay. Wow. So what are the reasons not to file bankruptcy?
Well, so going back to what I just said, for a business that has no assets, it typically doesn't make sense to file for Chapter 7. There's some people come
There's
say, "Oh
nothing
yeah,
to
I want
liquidate.
to." What's that?
There's nothing to liquidate.
There's exactly there's nothing to liquidate, and there's no benefit in a Chapter 7, a corporate Chapter 7, i.e., for some kind of business entity. The debtor does not receive a discharge the
Mm.
way an individual debtor would in a Chapter 7.
Ah,
So filing that 7 where there are no assets is just a useless exercise. Now, and moreover, there are times, again, in a Chapter 7, you have a third party, this Chapter 7 trustee,
mm-hmm.
whose job it is to determine whether or not there are any assets. And if there aren't any tangible assets, equipment, even a lease of value, the trustee has the right to and may scrutinize transactions between the company and its principals,
Mm-hmm.
which could include allegations of excessive income taken from the company.
Ooh.
So the principal can potentially get into a situation of potential liability unwittingly by putting the company into Chapter 7. That would be a major reason not for a company not to go into Chapter 7. Now, in terms of individuals, there are certain kinds of debts that, by operation of law, are not dischargeable, and it may be whether it's a personal situation or a business situation. Certain kind of tax debts are not dischargeable. So, in a case we're talking about where the business was failing and maybe the business owner failed to remit payroll taxes or any other kind of taxes that are due and is personally liable for those, which
Mm-hmm.
usually the business owner will be, those debts are likely not going to be dischargeable in bankruptcy. And if that's really the only basis for filing, that would be a bad reason to do it.
Right. Because
Um,
those are trust funds,
correct.
because they're sort of withheld and held in trust.
Well,
So,
right.
yeah.
Well, yes, there are the trust fund taxes like FICA, but they're also just regular tax liability that may not be trust
Oh.
fund
Mm-hmm.
or trust taxes, but that's also because it is a tax liability. It's accepted from discharge, i.e.,
Okay.
it's a debt that the bankruptcy code says is not dischargeable because, well, essentially, we're the government. You owe us the money, and we wrote the law. so we're not, now, I will point out that not all tax debts are, there is a common misconception that all tax debts are non-dischargeable. It's important if you have tax debts that are older, that you talk to somebody who has expertise in the bankruptcy field, because there are situations where older tax debts can be discharged in a bankruptcy proceeding.
Okay.
But I'm operating under the assumption in this conversation that we're talking about recent debts of recent vintage, which are not going to be dischargeable.
Got
And
it.
if you haven't filed tax returns for a particular year's taxes, those are never going to be dischargeable, no matter how old they are.
Wow. This is really a meaty conversation in topics. I mean, it's pretty serious these days. People have to make some very difficult decisions, and I thought it'd be a good idea to have this conversation with you just to air out some of the words, to
Sure.
understand what's dischargeable, what are the different chapters, what are exemptions, what are, all these terms that are flying around. We really want to give people something to think about, and I think you're a great resource. So if some of our listeners, readers want to get in touch with you or have a need and need some resources on better understanding, options around bankruptcy, where could they get in touch with you?
So you can reach me. My phone number is 212-929-7500. I'm at extension 1. And my email is very easy, as long as you can spell my last name, which is not so easy. It's my first name, Ethan, at ethangantzlegal.com.
Wonderful. Wonderful, wonderful. Is there anything else we haven't talked about or that may come to mind now that may be helpful given the situation most people are in? I as we were talking, thought of a funny topic, but then I thought I'll save it for a little bit later because
I do want, yes, I do want to make one point, because you mentioned the phrase or the term exemptions. I just want to talk about that really quickly. This applies to individuals. When I was talking about liquidation of non-exempt assets, there are certain, you don't lose all assets in a bankruptcy proceeding. There are certain assets that, again, by operation of law, are protected from the reach of creditors. Some of them are protected outside of bankruptcy by state law, and some of them, there are certain specific bankruptcy exemptions. One of the most common things that a lot of people have heard about is the homestead exemption. For policy reasons, and this varies from state to state, but in New York, for example, whether inside or outside of bankruptcy, there is a, depending on where you live, but let's just say if you live in the New York City area, there is an exemption of approximately $165,000 of equity per, and by the way, if you're a married couple, it's twice that much.
Oh, wow.
A married couple can exempt $330,000 in equity in a primary residence.
Okay.
So that means, and by the way, and to be clear, equity means what the value of the property over and above any kind of liens, and liens typically what we're talking about means mortgage or mortgages. So I mean that can be, doesn't sound like a lot, but if you have a house that's heavily mortgaged, probably don't have that much in equity, so you may well be able to save things like a house. And there are all sorts of other things. Qualified retirement accounts are exempt up to a very, very large amount. So a lot of financial, those kind of financial assets can be shielded in a bankruptcy proceeding and not made available to creditors. So
Wow.
if you're worried about, I have to be completely insolvent to file for bankruptcy, that's not the case. But again, best to talk to somebody to find out the details, because this is much too short of an opportunity for us to get into the weeds and talk about the eligibility requirements and all sorts of things like that.
But I mean, you're bringing up a great point. I mean, these were written into the law. I mean, it's part of Article 1, Section 8 of the Constitution, just like you said. So it's a protection. It serves a purpose.
Right.
Sometimes people get caught up in there's a stigma in it, or it means failure.
Yes.
But in reality here, there's a couple of options, and especially under the reorganization or the adjustment of debt, the Chapter 13, those really leave you some leeway to rework your life and rework what you're doing. And that's a
Yes,
good thing.
and I will also interject that in Chapter 13, one of the things that is helpful for a lot of people is that, for example, if they are delinquent on a mortgage, let's say, or other kind of lease, Chapter 13 allows debtors the ability to what's called cure and reinstate, which means if they continue to make the regular monthly payments, they can cure the delinquency, the past due amount, over the life of the plan, which normally, which is, in other words, they can essentially go against what the contract between themselves and the lender says, which would basically say, if you're delinquent, it's all due now. They can say, no, you know what, I'm forcing you to accept this repayment plan over a certain period of time. So it's a very powerful tool for people to get their lives, their financial lives together, again, in an orderly and equitable way.
Right. And this ends up in a lot of ways being everyone being better off, because if everything wasn't orderly, if there were lots of creditors coming and you're fighting, people tend to get nothing. Or if the person can't reorganize and can't get things adjusted, the risk is no one gets anything because it all goes to pot, right?
Or
So
yes, or again, the creditor who's the most aggressive
yeah, the most
gets
aggressive, right?
everything,
Right.
and everybody else gets nothing.
Right. Well, this was good. This feels like a nice little lessons, a throwback to why I didn't go to law school or become an accountant. So I really appreciate this conversation. I'm so grateful that I know brilliant people and that we could bring this kind of topic to our audience. And again, it's Ethan Ganc Legal. Did you say
Yes.
legal.com?
Ethan at ethangantzlegal.com. My last name is
Email with the
Ganc as in
website.
Charles. It's an odd spelling.
Mm-hmm.
But
And the website?
And the website is www.ethangantzlegal.com.
Okay, perfect. People will be in touch.
Thank you
Well,
so much,
thank you.
Robin.
Yeah, I appreciate it. Good seeing you.
You too. Stay safe.